in the matter of R versus Sadie Lane and John Letts.
Lord Hughes will explain the judgment of the court.
This appeal was about the correct meaning of one of the sections of the Terrorism Act 2000. It is a preliminary appeal in a criminal case where the trial hasn't yet begun. That means that no one yet knows what the real dispute or disputes may be at the trial, still less how far the legal question which the court has been asked will in the end figure. Because this is a preliminary criminal appeal, it is very important indeed that nothing is reported which anyone could suggest might influence the jury when the trial comes round. So the statute which allows appeals like this lays down reporting restrictions. They apply to this case and they're set out at the end of the judgment. The judgment can be reported along with the names of the defendants, the charges as they are summarised in the judgment, and one or two other details like the names of counsel and solicitors. But what there cannot be is discussion in advance of the trial of the case which is likely to be put forward either by the prosecution or by the defence. The legal question which the court was asked concerns the offence of entering into funding arrangements connected with terrorism. It's contained in Section 17 of the 2000 Act. The section makes it an offence to enter into any arrangement under which money is or will be made available to someone else if the arranger, the sender of the money, knows or has reasonable cause to suspect that the money will or may be used for terrorist purposes. The question which is asked is about the correct meaning of that requirement, that the defendant must be shown to have, quote, known or had reasonable cause to suspect, unquote, that that's where the money might end up. Does that mean that the defendant is guilty if he either knew or had reasonable cause to suspect this, or does it mean that he must actually suspect, and moreover with reasonable cause? The answer to that depends on reading the statute in the ordinary language which it uses. The court's unanimous answer is that the section clearly does provide for alternative ways in which the offence can be committed. It's either a defendant who knows or a defendant who has reasonable cause to suspect, not necessarily one who actually suspects. And that reading is confirmed, as the judgment explains, by the fact that earlier versions of this offence in previous statutes were couched differently. The earlier versions did say that to the offence to be committed, the defendant must be proved either to know or to suspect. In other words, they said actually suspect. But there has been a change in language that must have been deliberate, and it can only mean one thing, which is that the change was intended to widen the offence to those who had information on which any reasonable person would suspect that the money might end up in terrorist hands. Although, of course, it's true that courts try to interpret criminal statutes in a way which requires some guilty state of mind in a defendant before he can be convicted, that's a presumptive approach which can only be applied so far as the words of the statute allow it. Here the words are completely clear. Moreover, they do provide a form of words which requires proof of a culpable state of mind. They require that before the defendant can be convicted, he or she has to be proved to have had information which a reasonable person would see gave rise to the suspicion that the money might end up in terrorist hands, but sent it anyway. That is the conclusion which the Court of Appeal had reached. So the outcome of the appeal here is that the defendant's appeal against the Court of Appeal decision must be dismissed. I add again, whether the point will in the end arise at the trial remains to be seen in the future. This court's decision about what the statute means is no kind of advanced determination of whether these defendants are guilty or not. That must await the trial and whatever evidence is advanced on each side there.
The court will now adjourn.